In this video, we will continue our series on the dangers of a university student disciplinary hearing. Today, the topic is self-incrimination, and that discussion is coming right up. I'm Steve Gustitis, and this is my channel, Gustitislaw. If you're new to Gustitislaw, I post weekly videos about how to manage encounters with the police, how to effectively navigate the criminal justice system, and how to defend criminal charges. I welcome questions and I welcome comments, and I will respond to those as quickly as I can. If you like the video, consider giving a thumbs up, and if you enjoy my channel, please consider subscribing. In any case, I appreciate you being here and being a part of the Gustitislaw community. This video is video number 2 in a 3-part series on the dangers of the university student disciplinary hearing process. Links to other videos in the series can be found down in the description section. Today our focus is on self-incrimination and law enforcement's ability to get a student's confession simply by issuing a subpoena to the university. Students can unknowingly incriminate themselves during these university hearings. This is especially true if the student is under criminal investigation or if they have criminal charges pending. Unfortunately, this is a very, very common scenario, especially in the case where the student has failed to employ the help of a professional advisor to help shepherd them through this hearing process. When students interact with university officials during these disciplinary hearings, they are often encouraged to give their perspective or their side of the story. Unfortunately, when the students do, they often incriminate themselves or, at a minimum, paint themselves into a corner. The big problem is that these discussions with the university are often tape recorded. That brings us to point number 2 in today's discussion. Federal law does not protect the privacy of these incriminating statements made by students during the hearing process. The Family Educational Rights and Privacy Act, also known as FERPA, generally protects the privacy of these records. Records can only be released with the written consent of the student or their parents. However, there is a law enforcement exception to the FERPA rules, and if a student is under criminal investigation, or if the police or the local prosecutor believes they can use those statements in criminal court, all the police have to do is to obtain a subpoena and issue it to the university, and they will release the records without the student's consent. If the student has confessed or if the student has made incriminating statements to the university officials, the police need only subpoena that tape, plug it in, and hit play for the judge or jury. Instant conviction. I hope you can see how dangerous this hearing process can be for students. And I'm interested in what kind of ideas that you may have about how a student can protect themselves during this process. If you have a question, if you have a comment, add it down in the comment section and we will begin a discussion. Remember, if you like the video, please give it a thumbs up and don't forget to subscribe. Our next video will be part 3 in this series, and until then, I look forward to seeing you. Thank you for visiting Gustitislaw.